Institute is dedicated to the building of African capacities in the field of international law and to the consolidation of the rule of law in the continent in general. Why a series of webinars? As you can imagine, the educational and training activities of the Institute have been affected by the COVID-19. And since all these activities were carried out in the past in person and involved the travel, presence, and participation of lawyers from all over the African continent, the Institute had to shift its activities online and continue with the skills development and training activities in the form of training courses, online training courses, and webinars. The webinars are thus designed to be part of the activities of the Institute, and they are designed to provide an avenue for substantive engagement and continuous learning for African scholars and practitioners in the fields of international law and African Union law. So you can look forward to monthly webinars on various aspects of African Union law and international law, and you can always consult the website of the Institute to find out about the theme of the next webinar. The website of the Institute is AIIL-EADI. That is the acronym in English dash the acronym in French. So you can always find that, or you can simply Google African Institute of International Law. The theme of our webinar today is investment treaty arbitration involving African states and state entities, key issues. The key words here are investment treaty, arbitration, and African states. Those are the three keywords. And of course, we know what are the key issues, but I'm quite sure that the speakers will elaborate on them. But I would like to mention three key issues on which I hope the speakers will enlighten us, but they can, of course, add other issues to those three issues very quickly and in a telegraphic manner. The first issue is the issue of the applicable law. Do African states scrutinize? And by applicable law, I mean the investment agreements themselves and international law, whether it is public international law or private international law. Do African states scrutinize the investment agreements which they sign and conclude with others? Do they have the capacity in international law to be able to check what they are getting into as far as the applicable law is concerned? The second issue is representation. Representation before the arbitral tribunals and representation in the tribunal itself. Do African countries have the capacity to have their own counsel represent them before such tribunals? And do they appoint African arbitrators to the arbitral tribunals in which they participate or they have to participate? The third issue is the issue of the venue of the arbitration or arbitral tribunal. Are they held when they concern African states and state entities? Are they being held in Africa, or are they delocalized? And if they are delocalized, which we know is the case, uh, is most often the case, what are the consequences for the African states and state entities? Do the people of Africa know about the results of those arbitral tribunals? Are they aware of the outcome of those tribunals? Can African scholars know what happened in arbitral tribunals concerning their own countries and their state entities? So I just put these questions on the table with respect to these three issues, but I'm quite sure that these are not the only three issues. And we have four speakers today who are well known in the field of arbitration and who are also at the same time scholars in the field of international law. The first two keynote speakers, whom I will introduce right now, are Professor Kawar Qureshi and Mrs. Dayamana Diawara. And then their speeches will be followed by the commentaries of Professor Adelardus Kilangi of Tanzania and Madame Huguet Yvonne Ekume of Gabon. So let me introduce, first of all, the first two speakers. Professor Kawar Qureshi is a QC, Queen's Counsel, and specializes in commercial litigation, international arbitration, and international law, and practices from Searle Court, London, as well as McNair Chambers in Qatar. He is a visiting professor in commercial law at London University, and he is consistently identified as a leader in his fields of practice. And he has represented more than 70 states in arbitral proceedings and has also appeared several times before the International Court of Justice. And he has also represented a dozen African states in arbitrations. Mrs. Dayamana Diawara is the director of the International Court of Arbitration of the International Chamber of Commerce for dispute resolution services in Africa. She was previously a counsel at the Secretariat of the ICC Court for 5 years. Mrs. Diamana is also a practitioner, and she practiced in the office of Dentonis in Paris before joining the ICC Court of Arbitration. She is a scholar, and she lectures in the Master 2 program in international commercial law at the University of Paris-Nanterre in Paris, near Paris. And she is a member of several professional networks.